Welcome to secretarial practice class. So this is the third class. So in the last class we have dealt with the appointment of company secretary. So in this class we will study regarding the dismissal of company secretary and the reasons for the dismissal of company secretary. What is this dismissal of company secretary? So dismissal of company secretary is nothing but it is the removal of company secretary. You are going to dismiss the company secretary. So what may be the reason? So as we all know that a company secretary has a great role in every stage of company formation. But a company needs to dismiss secretary for some time, or for some reason the company is going to dismiss the secretary. Okay, they are mainly accountable for the professional management of the company. So in relation to ensuring the observance and constitutional and authorization requirements and ensuring that the board decisions are effectively implemented. So we are going to describe those reasons for dismissal of company secretary. So why secretary is been removed? So he can be removed by giving the notice in writing or compensation for that. Okay, and a company secretary can be dismissed or removed by the board of directors in some situation. So the first situation is dismissal of company secretary on the ground of disqualification. Okay, so on the ground of disqualification means here, so it is said that if the board of directors are not satisfied with the work of the company secretary, so in such case the board of directors are going to remove the secretary by giving them the prior notice. So prior written notice. Okay, a company secretary is an employee of the company, so we agree with that, and already we have studied the role of it, right? So company secretary is an employee of the company, so he is generally appointed for the certain period. So employer and employee relationship exists between the company and the secretary. Whenever a person is appointed as a company secretary, an employer-employee relationship exists between them. So if the board of directors is not satisfied with the work of secretary, they can terminate. Okay, so they can terminate him subject to serving a written notice. So as it is given, so we have to give a written notice to the secretary and mention in the contract of service. If the board of directors is not pleased with the performance of the company secretary, then he can eliminate, or they can eliminate him giving a prior written notice. So we know if somebody is going to employ me, so he will be the employer, and if he is not satisfied with my work, so he has a right to dismiss me or remove me from his office, right? The next dismissal reason or the ground reason is irregularities of company secretary. Okay, irregularities. So the company secretary may be dismissed without reason. So in this case we can see he can be dismissed without reason, not without reason, without notice, if he is charged with willful disobedience, misconduct, immoral things, negligence of duty, permanent disabilities, etc. Which means if he does something willfully means what? Something we do without knowing, so that we call it as mistake. We know it but still we do it, what we say, it is a fraud, right? So we can say that a company secretary can be fired at any time without any prior written notice if he is being suspected, or if he has been proved he is a fraud, or he is going to break the code of conduct, means rules, or he is going to do something immoral, he is neglecting his duty, or he is not is not having ability, permanent inability we can say, or lack of confidence in interpersonal skills. So in such case, the company secretary is being removed. Then the next is dismissal of company secretary on the ground reason of end of the contract of the company secretary. End of contract. What does it mean, end of contract? So end of contract means here we are company and the secretary. So they have the contract, right? So contract like, so he may be appointed for some particular period. Okay. So in such case, what happens? A company secretary is selected for the permanent term. If the board of directors does not renovate the agreement, then what happens? The agreement ends up routinely. So we have to renew the contract. So board of directors have to renew the contract. So only when they are going to renew the contract, so only then they can continue. Suppose they are not going to renew the contract, what happens? So here he have to end up automatically, right? So it is said that a company secretary is appointed for the fixed period, and if the board of directors does not renew the contract, then his contract ends up automatically. Okay, the next is winding up of company. Okay, winding up of company, what do you mean by this? Winding up, which means we are going to end up, we are going to liquidate the company. So we know employee and employer relationship exists between the company and the secretary. Suppose the company is going to close, all the employees have to move back to their home. Yes, so they have to be terminated. So as others employees are discharged, secretary is also discharged. Okay, so it is said that during the winding up of company, the company secretary is discharged like other employees. Okay, like other employees. During winding up of the company's secretary is discharged like other employees. An employer-employee relationship exists between the secretary and the company. If the board of directors, okay, is not satisfied with the performance of the secretary, so as I said you, they are going to give the prior notice and they are going to send them out. If winding up takes place before the termination of fixed period, then what happens? You can argue for the compensation for the break of contract or breach of contract. So as I said you, employer-employee relationship is going to be existing, and employer has a right to throw out or kick out or fire the secretary by giving the prior notice. But here the company secretary is appointed for the fixed period. So the contract is there. So before the end of contract, if the company is going to wind up, what happens? We are going to breach the contract, right? We are going to break the contract. Contract is been broken. So in such case, what happens? The company secretary is under the loss. So he can claim for that. Okay, so he can argue for the compensation for breaking out the contract. So there are some other ground reasons we can say. So like you are going to convey the board meeting first. So after becoming aware of all the directors, when they are aware, a board meeting shall be called, okay, in order to take the decision whether to remove the secretary or not. If company secretary's name is there in the articles of association, so what happens? Sometimes the first secretary, the protem secretary, his name will be there in the articles of association, and the directors, what they do in their first board meeting, they appoint the same director. So same secretary they are going to appoint. So in such case, what happens? The name of protem secretary will be there in the articles of association. So now we are going to change the secretary. What happens when you are going to change the secretary? So you are going to change the articles of association also. Okay, so then next you are going to give intimate or intimation to the secretary. So secretary is been removed, so that should be known by the secretary also. The secretary to be removed shall be intimated concerning the board decision and should be asked to give the demonstration to the board within 15 days of intimation, and then the second board meeting will be conveyed. So thank you.